Hello and good afternoon, everyone. Thank you for joining us. My name is Gail Karish. I'm going to start the presentation with an outline of the topics. You can go to the next slide. Outline of the topics that we're going to cover this afternoon. I'll do a brief description of the merger transaction and cover the CPUC proceeding and timeline. Then I'm going to hand it over to Joe Van Eaton, who will talk about the what's going on at the Federal Communications Commission. Then Martin will talk about some of the impacts, and then back to Joe to kind of close the session out with a discussion of how you might participate in this merger transaction review. Next slide. So briefly, the merger is a big one. It's Charter, who is the 4th largest cable provider, merging with Time Warner Cable, who is even bigger, 2nd largest, and acquiring Bright House Networks, which is the 6th largest cable provider in the country. The deal with Time Warner Cable is valued at $56 billion. Bright House will be another $10 billion and change. Martin will talk about some of the impacts of just the size of that deal and the financial situation that leaves New Charter in. New Charter will become the 2nd largest broadband provider after Comcast. Next slide. And this is a pro forma sort of showing of the numbers post-merger with New Charter at 19.4 million internet customers. Next slide. Charter will also become the 3rd largest pay TV service provider, and this map shows the spread of their service areas in all around the country. So you see more heavily probably in Southern California, but in parts of many states in the U.S. Next slide. So I'm going to talk about the CPUC proceeding that is already underway. But before I do, I just want to, as a kind of a preface, say that so Charter and Time Warner Cable have telecom licenses in California that were issued by the California Public Utilities Commission. They both also have state video franchises that were issued by the California Public Utilities Commission under DIVCA, the Digital Infrastructure and Video Competition Act, which you may recall is the statute that took local franchising away from, local cable franchising away from local entities such as cities and counties and put it to the state level. They also have some local franchises still in some jurisdictions because those have not all transferred over or rolled over to state franchises. So on the cable side, if you have a local cable franchise, you should have already received a Form 394. And there are a few jurisdictions I'm aware of who have. If you have a state video franchise, it's a little bit unclear what kind of review might be done by the PUC for DIVCA transfers. But it seems like it'll be fairly pro forma. So there may be an opportunity to object, but the real action is going to be in this proceeding that I'm going to talk about now, which is the proceeding that's already started that is reviewing the transfer requests for their certificates of public convenience and necessity, that is their telecom authorizations. So the CPUC, in looking at a transfer request for CPCNs, must find the deal provides benefits for ratepayers, it equitably allocates economic benefits to shareholders and to ratepayers, it doesn't adversely affect competition in telecom services, and it is in the public interest. And they have, next slide, they have set out in the statutes 8 public interest criteria. This is a sort of a summary of what the 8 are. I'll only touch on a few that are particularly important for our jurisdictions, looking at the transfer, the financial condition of the resulting company, the quality of the service, the overall impact on communities that are being served by the resulting company. and whether there should be any mitigation measures to prevent significant adverse consequences which may result from this transfer. Next slide. So the CPUC proceeding was launched with the filing of the applications on July 2nd. It's been determined to be a rate setting category hearing or category of proceeding, which is kind of a catch-all category, but also has been determined preliminarily that a hearing may be needed. The administrative law judge has already been assigned. It's the same ALJ who reviewed the Comcast Time Warner application. Protests have been filed by several different entities, and they've raised issues of competition, service quality, broadband, voice over IP, reliability of service, a fairly broad range of issues. Next slide. So where we're at now is we don't have a firm schedule yet for when the rest of the proceeding will happen, but it will. The next step should be coming very soon. There will be, in all likelihood, a pre-hearing conference where additional issues can be raised. Then that will be followed by a scoping memo, which will outline the formal hearing schedule and the issues that are going to be discussed in the hearing. Then they will have the actual evidentiary phase and potentially public hearings or just paper filings and hearings. And then that will be followed by the proposed decision of the ALJ, which is subject to a 30-day public review period and more opportunity for comment. And actually, if you were following what was happening in the Comcast Time Warner Cable merger, that's as far as we got. There was a proposed decision issued by the ALJ. There were comments filed, and then before it went to a vote of the commissioners, that's when Comcast pulled the plug on that transaction. So that's the outline of the proceeding. We don't have precise timelines yet, but we expect that we should have them pretty soon. Next slide. And that's my part on the CPUC, and now I'm going to turn the mic over to Joe so he can talk about what's going on at the federal level.
Okay. At the same time, the state level proceedings are going on. There are parallel proceedings going on at the Federal Communications Commission to consider whether the merger should be approved. The Communications Act requires FCC approval of transfers of licenses that are used in conjunction with the operation of a cable system. And although it might not be obvious, there are many, many licenses that are actually held by Time Warner and Charter and that they need to have in order to provide cable services. So basically, when you go to an FCC proceeding, a person who wishes to merge or the applicants bear the burden of proving that the deal is in the public interest, convenience, and necessity. So the FCC can base a decision to grant or deny on a determination of what the deal's approval might do to affect diversity in the marketplace of ideas, competition, localism, any number of issues. And the FCC decision will be afforded considerable deference if it's both as to the decision to deny or a decision to approve and impose conditions. Next slide, please. The FCC proceeding is also underway right now, and theoretically, the FCC has set itself a target of resolving applications for mergers in 180 days. However, that deadline is not a real deadline at all. The FCC routinely stops its own deadline clock and allows itself more time to act. So basically, the FCC got the application in June. In July, it announced that it would be coming up with, it announced the transaction, but it wasn't until last week that the FCC actually announced deadlines for action in the proceeding. So right now, the FCC has asked, it has announced a proceeding that basically has a comment period, a response period, and a reply period. The FCC takes those deadlines fairly seriously, but it also allows anyone to submit comments ex parte on this proceeding. That is, outside those deadlines, it just may or may not take those comments into account. It usually does take them into account. So the first deadline, the deadline for folks who oppose the transaction, is October 13th. Those who either support the denial or opposition to the petitions are due on November 2nd, and then the last round of replies would occur on November 12th. And after that point, the matter would be in the Commission's hands as to how quickly it acts or doesn't act. And the staff the FCC staff may itself ask many, many questions of Charter and Time Warner and begin to consider what should happen. And again, its choices are approve without conditions, deny, or approve with conditions. And it commonly does approve with conditions. When Comcast merged with NBC Universal, for example, the Commission imposed several conditions that were designed to make sure the company did not abuse its control of programming to harm the public. One of the outgrowths of that merger was the creation of a program called Internet Essentials that some of you may be familiar with, under which Comcast was required to offer a low-cost Internet service to low-income families. That program has received plenty of criticism, but it in fact also represented a step forward, or at least one step in the direction of making broadband services available to people who often can't afford full-price services. One of the issues we expect to come up in the FCC proceeding, and that could also come up in the proceeding at the CPUC that Gail talked about, is whether there's going to be a requirement for Internet Essentials or some similar program as a condition of this merger. And that's an example of an issue where local governments can play a significant role in sort of urging regulators at the federal or the state level to impose a condition that's designed to ensure that consumers have access to low-cost service. And when you get to Martin's point of the presentation, I think you'll see why it may be important to have that type of condition, given both concerns about the economics of this deal, but also given the market power the combined entity may have. And we know that this is likely to be a significant concern because right now Time Warner does offer its own version of an Internet Essentials service. It offers an Internet service for $15 a month, but the service that and we also know Charter is suggesting that it will offer some form of Internet program, but as we understand it, it's offering a service that's almost 3 times more expensive than the Time Warner service, and it would be limited as to the number of people who would be eligible for that service. So those are the sorts of issues of concern that we expect can be and ought to be raised and should be of interest to governments that are interested in dealing with broadband deployment issues. So there's going to be an opportunity to participate at the FCC and the CPUC. The CPUC deadline, the CPUC at this point is in the midst of the hearing process. The FCC has established a deadline, so moving quickly to participate could be important, and recognizing the deadlines will also be important. Next slide, please. So let me turn it over to Martin, who will explain, and then I'll come back on, but Martin will explain why this merger may be of concern to local governments and why participation may be useful.
Thank you, Joe. I will raise some points about what I think might be the future of New Charter, this new company that will be created, including Charter, Time Warner Cable, and let's not also forget Bright House Networks, which, while concentrated in Florida, also has a few franchises in California. It is indeed a big deal. Now, there have been a number of people who've argued that it's more likely to be approved than the Comcast-TWC merger because it's not creating a bigger number one, it's creating a new and more powerful number two. And that is certainly true in terms of current market share. Also, the point has been made that the new charter does not have the same extent of vertical integration. It doesn't own anything as important as NBC Universal as Comcast does, and therefore there's little risk or less risk of abusing its position with respect to providing video services favoring its own over those of third parties. Nevertheless, if you look across the country, you realize that new charter will in fact cover just over 40% of all U.S. households. Also, most significantly, it will start life with a huge debt load. Now, you shouldn't take these figures as being absolutely true. They may not be quite up to date. I've seen various estimates of anywhere between sort of 66 to 76 billion, which is a huge debt load, and a significant proportion of which, certainly I think well over a quarter, will be junk debt. And that can be compared to annual free cash flows of New Charter, which if you look at what they've been able to achieve separately together, it's probably around $3 billion. And to contrast that, Comcast is in a much more powerful financial position and would have had annual free cash flow of about $10 billion if its proposed deal with Time Warner Cable had been consummated. Now, elementary math tells you that with an annual free cash flow of $3 billion, you may have problems, particularly if, as everybody keeps saying, interest rates go up and therefore the cost of servicing the debt. I mean, you can easily see that $3 billion is not sufficient to, it's sufficient perhaps to cover an average interest rate of perhaps 5 or 6% a year. But junk debt, even at its historically low levels, would typically command these days about 7 to 8%. Could we have the next slide, please? So this shows, this is just the equivalent of what Gail showed earlier on a national basis, what the coverage of New Charter would be in California. And I emphasize here that the deal is certainly much more significantly impactful in broadband than in video services. The total number of broadband subscribers is greater, both for New Charter and indeed throughout the cable industry, an event that first took place last year sometime, that crossover. And the margins in broadband are much higher. And therefore one can expect that increasingly, particularly with the growing phenomenon of cord cutting, in which people basically get their video services over broadband connections, not through traditional cable TV services, and possibly in some cases with free over-the-air digital terrestrial broadcasts, that trend is likely to continue. Next slide. So it seems obvious that in order to service its debt, New Charter is going to face strong pressure and incentives to increase its free cash flow. Now, how can it do that? Well, there are a number of ways open to it. One, of course, is that it can reduce its investments, which would mean perhaps not expanding networks to cover areas within a particular county that are not yet covered, and not upgrading the networks in a timely manner. It may cut its operating costs, and the obvious way to do that is to lay off staff that are used for maintenance and customer service, scrimping on customer care, and then, of course, actually increasing prices to customers. And there are a number of ways that they can do that. One of the aspects of this are rental charges for equipment that they oblige their subscribers to use. We don't have the equivalent of a Carter phone in the cable TV business, in which you can bring your own device very easily, or you can buy your own device and connect it to the network. Often, in many cases, it's very difficult for you to do that or there may be ways, in fact, in which they find they restrict the number of services you can access on a device that you may wish to acquire. And these rental charges have been going up. They increase them at will, and they continue well long past the time when a particular piece of equipment may already have been paid for with a healthy margin. And then there's this interesting phenomenon of so-called administrative fees, which, if you read the small print, mean they're not fees that are linked directly to any tax or other charge required by the FCC. They are, in fact, if you like, fees to administer the collection of those charges that are mandated. Now, suppose none of this works, then the alternative is for New Charter to declare bankruptcy to reduce its debt. And this, of course, would further disrupt or delay network and service improvements and possibly enable them to escape paying some of the franchise fees that counties are counting on. Next slide. The other concern needs to be raised in all of this is the record of the parties involved in this deal. Charter itself has already been through bankruptcy. It acquired a very high debt load and in the end went bankrupt and got out of bankruptcy in 2009 after reducing this debt load by $8 billion. And then the record of John Malone, who in practice, if you look at the governance structure of New Charter, will be the most influential shareholder through Liberty Cable. In his previous cable operation, and I realize that some of you may be too young to remember that, in the late 1990s, but when you look at the record of that operation and how it cut back on investments when it got into a financial difficulty, and he was able to get out of it by, in fact, finding a relatively naive buyer for TCI, which was AT&T at the time. So the question is, what priority will New Charter give its customers, and how will it, in fact, fulfill its commitments that it may make in order to achieve approval of the deal compared to pressure from the people to whom it owes money? So I think that there are substantial risks that New Charter will be unable to fulfill any commitments that it may make about investments, improved customer care, jobs in the US, etc. And I've noticed that already in the FCC proceeding that Joe referred to, there have already been a number of submissions from municipal chambers of commerce, charitable organizations, minority organizations, and so forth, all saying, oh, we support the merger because clearly it will lead to more jobs in the US, additional investment, etc., etc. And my experience is that this is part of a typical playbook of large corporations that want to make these kinds of mergers. They offer various goodies to small organizations that don't have the expertise or knowledge truly to evaluate whether what they're being told is true, in exchange for which they get their support. So overall, I think that because of the financial conditions associated with this merger, which play a role with the CPUC as well as with the FCC, that there are strong reasons to raise concerns and risks, and that these risks, if in fact they turn out to be true, could have a significant impact upon counties in California and other local, municipal, and even state authorities in terms of their ability or the ability of New Charter to meet the kinds of commitments they want, particularly with respect to broadband. And that is significant because in many places in the country there are in fact only two fixed broadband operators that are likely to be able, that are key to making the investments that are needed for the future. And so if one of them goes bankrupt or is in a financially weak situation, that will be bad for competition. Next slide. So I'll turn it over now back to Joseph.
So let me turn now to sort of what you can do or how to participate if you're concerned about the Charter merger. Let me say there's one obvious avenue open to any community short of participating in these proceedings, and that is to meet with Charter and Time Warner to raise your concerns and see if you can reach a valid enforceable agreement that addresses particular local issues that are of concern to you with respect to the some of you, for example, who may already have Charter and are facing efforts by Charter to not pay PEG fees, to not pay, to charge you for connections to send video programming upstream on their cable system. Those may be issues you can address locally. However, short of addressing issues locally, even if you can address issues locally, in theory, it's always a good idea to keep your eye on these open proceedings and their deadlines, because your opportunities to influence those proceedings depend on timely filings. And in those proceedings, it is possible to come in and get conditions that can help your community. Martin raised some concerns about broadband deployment, for example, and the real commitment of the company, or Charter's commitment or ability to commit to expand broadband. Well, I suspect one of the issues the CPUC will consider is whether the company, in fact, does have financial resources committed to California to do what it claims it will be able to do. The company is justifying the merger based on its contention. So if you want to affect, one of the ways the company is justifying approval of the merger is that the combined companies will have more resources to invest in broadband than the companies would have separately, and that they will be able to pursue an effective broadband deployment plan if they are allowed to combine. If that is the case, if that's the justification, it would be perfectly reasonable for California counties to come in and say, essentially, show us the beef. Let's see a definite commitment plan, because the money, one way to look at the money, the companies say, forget this debt issue. We've looked at that issue closely. We are going to be able to do what we promised to do. Martin's pointing out that there's certainly reasons to be concerned about the numbers, and a resolution might be come up with some sort of definite commitment plan in California for deployment, particularly in rural areas. So there are all sorts of ways to raise these issues. My point was that there will be opportunities for people to participate, and there's three basic ways people can participate, or communities can participate. One is obviously individually, and in some ways that's the easiest way. The other is as a coalition, if you've got neighboring counties that are facing similar concerns. And I'd suggest to you that the list of attendees provides a nice model for folks to exchange information and to decide whether they can work together jointly. We'd certainly be happy to work with any community who's interested in this proceeding. We are going to be working with some communities that are concerned about this proceeding, and particularly with respect to some of the cable issues associated with Charter's provision of service in California. And the third way is obviously through associations. One of the questions we received was, is this organization taking a position? I can't speak for the organization. Thus far, they are not a party in this proceeding. So I think right now it will be up to the individual counties who wish to participate in this proceeding to become parties. And that is actually fairly simple to do. Gail can speak to that issue in more detail. But if you're interested, particularly at the CPUC level, in participating, you really need simply to file a piece of paper there, and it's routinely granted, even at this stage. But you want to get in as quickly as possible.
Yeah, the best way to participate at the CPUC is you file a very simple motion for party status, or you actually attend the pre-hearing conference that they're going to have. Of course, they haven't set the date yet. So it's a simple filing you can do online to request party status.
With that, we can turn to some of the questions. The first question I have is, with Internet Essentials, will Charter be required to build out digital in all areas where they have declared that they will not be building out old analog systems? And the answer is, it's going to depend on what proposal is ultimately approved. The the current proposal, I don't read that way. I don't see any real commitment to do any additional build-out that would be enforceable in any way. What I see is a commitment to some form of service that will be available to low-income folks, but I think that the service that's proposed it's highly questionable whether it would be of much value.
We'd like to thank everybody for attending then, and thank you to our presenters for making themselves available for this very informative webinar. And we will keep you informed as to our upcoming webinars through our bulletin, which you can sign up for at our website, and through our Twitter account. We will see you all next time.